The core conflict in financial remedy proceedings comes down to a simple mathematical problem, dividing a finite pool of assets between two separating, hostile parties. Left unchecked, this conflict introduces a severe risk. The legal warfare required to decide who gets what can easily become so expensive that the legal fees consume the very assets the parties are fighting to secure. To prevent the complete exhaustion of family wealth, the legal system relies on a rigid statutory framework, Part 9 of the Family Procedure Rules 2010. Part 9 operates as an engineered, forced disclosure pipeline. It introduces a sequence of mandatory deadlines and filings designed to reveal the full financial picture before the final trial. Before looking at the specific timeline, we have to understand the theoretical framework that dictates every decision a judge makes in these cases, known as the overriding objective, found in Part 1 of the rules. This diagram illustrates the mandate of the overriding objective. It requires the court to deal with cases justly and ensure parties are on an equal footing, but it places equal weight on saving expense. This horizontal axis represents how Part 9 enforces proportionality. It builds a gauntlet of mandatory steps and rigid deadlines. It even requires parties to continually file Form H cost estimates before every hearing, forcing everyone to acknowledge exactly how much money is bleeding out of the marital pot. Every rule, form, and hearing you will encounter in Part 9 exists to serve this exact goal, delivering justice that is strictly proportionate to the financial realities of the dispute. We begin at the far left of the timeline with the initial mandatory pre-action step. Practice Direction 9A dictates that before entering the court system, parties must attend a Mediation, Information, and Assessment Meeting, or MIAM, to explore out-of-court dispute resolution. If mediation fails or is bypassed, formal proceedings are triggered by issuing Form A, an official request for financial relief. Modern family practice requires practitioners to issue Form A via the designated digital online portal. This action registers the dispute directly into the court's architecture. Once Form A is issued, the dispute enters a mandatory structure. The parties no longer negotiate on their own terms. They are now subject to the court's calendar and its powers to compel disclosure. With the clock running, the parties face their first major procedural hurdle, the exchange of Form E. Form E is a comprehensive, mandatory financial statement. It requires an exhaustive, verified account of all financial circumstances, demanding heavy documentary evidence like payslips, mortgage statements, and property valuations. Looking at our timeline, the rules impose a strict limit. Form E must be exchanged between the parties and filed with the court no less than 35 days before the first appointment. This document demands absolute full and frank disclosure. Under the precedent of Livesey v. Jenkins, attempting to hide assets or minimize wealth carries severe consequences. If discovered, the court will penalize the offending party with heavy costs orders or even set aside any final order entirely. Form E acts as the system's spotlight. It forces the true financial picture into the open so that genuine, fair negotiation can actually begin. With the finances disclosed, preparation begins for the first appointment, or FDA. Strict compliance is required 14 days prior to this hearing. The parties must file very specific documents: a concise statement of the issues in dispute, a chronology of the relationship, and a questionnaire targeting any missing information in the opposing party's Form E. This flowchart illustrates the FDA's true purpose. It is strictly an administrative case management hearing. It takes those document inputs and produces procedural outputs, like orders for joint expert pension or property valuations. It is not a venue for financial negotiation. Because the FDA is purely administrative, the courts highly encourage what is known as the accelerated procedure. If the parties can agree on the necessary directions in advance, they can file standard documents, known as the ES-1 and ES-2, alongside a draft directions order, and bypass personal attendance at the FDA entirely. Bypassing a court appearance saves thousands of pounds in barrister's fees. This perfectly executes the overriding objective, preserving more of the asset pot for the family. The timeline now reaches the second major milestone, the Financial Dispute Resolution Appointment, or FDR. Notice that it sits inside a shaded without prejudice zone. Before entering this zone, the parties must lay their cards on the table. Exactly 7 days before the FDR, both sides must file details of all their settlement offers and proposals. The FDR is unique. It is a privileged, judge-led negotiation. Because it operates on a without prejudice basis, The parties have absolute reassurance that the offers they make in this room cannot be repeated or used against them later in a trial. The judge at the FDR plays a highly specific role. They review the assets, listen to the arguments, and provide an expert, neutral evaluation of what a final outcome might look like. However, they have absolutely no statutory power to impose a final order. To protect this privilege entirely, a strict firewall rule applies. The FDR judge is permanently barred from having any further involvement in the case if it proceeds to a final hearing. The FDR functions as the system's primary mechanism for settlement. By providing a judge's perspective early on, it forces both sides to evaluate the risks of continuing to a trial. Following the FDR, this diagram shows the timeline fracturing into two potential outcomes. The upper path represents a successful negotiation, resulting in a consent order. If the parties reach an agreement, they draft a consent order utilizing the standard family order precedents approved by the president of the family division. A properly drafted consent order relies on a specific anatomy. It requires clear definitions, substantive orders, recitals outlining the background agreements, and undertakings. Undertakings are critical in complex settlements. These are legally binding promises made directly to the court. For example, a promise to take specific steps to mitigate capital gains tax. The court cannot order these actions statutorily, so they rely on the parties agreeing to them voluntarily. A sealed consent order is the intended, optimal function of Part 9. The parties retain control of their financial destiny, reach a compromise, and preserve whatever remains of their asset pot. When the FDR fails, the case drops to the lower path. Barreling toward a final hearing, the procedural environment instantly shifts. The protective veil of without prejudice privilege drops permanently. Under FPR Rule 9.27a, the parties now have exactly 21 days after the FDR to file open proposals for settlement. Unlike the FDR, the trial judge will see these open statements, and the amounts requested are fully on the record. The administrative burden also skyrockets. The applicant must compile comprehensive, paginated trial bundles that strictly comply with Practice Direction 27A, driving up legal costs right before the trial begins. Reaching a final hearing is a systemic failure of negotiation. It transfers all decision-making power and all judicial discretion entirely away from the family and into the hands of the state. Looking at this completed chronological journey, from the initial Form A trigger through the forced disclosure of Form E, to the crucible of the FDR, the true cost of litigation becomes visible. At every node, wealth is lost to legal fees. Pushing a case all the way to a judge for a final hearing carries massive financial and strategic risk. A third party will ultimately decide the division of a family's life's work. Part 9 of the Family Procedure Rules is an escalating pressure system. By making the alternative to settlement so procedurally exhausting and financially ruinous, the law compels parties to sit at the table and find a fair compromise.